Leading up to this point, we have discussed our understanding of the law, including different classifications of the law and how our legal system moves through and progresses. We've also discussed ways to get into court, known as jurisdiction, and the setup of both our federal and state system. In this lecture, we are going to continue our discussion of the court system, really focusing in on the legal process.
We can break the stages of litigation into 3 different parts: pre-trial, trial, and post-trial. So typically the life cycle of a lawsuit starts with an accident, a breach of contract, or some other dispute or event that causes someone to want to file a lawsuit. Then what happens is the party who feels wronged hires a lawyer. That lawyer is going to file a complaint. The complaint is plaintiffs initiating documents to start a lawsuit. And it notifies defendant, what's called service. It serves defendant so that they have a formal notification that there is a lawsuit pending against them. Then defendant's attorney will file an answer or sometimes a motion. This is defendant's response. Then what happens after this pleading stage is discovery. So the parties will exchange evidence, they'll exchange information that each side knows, they'll talk to witnesses, they're going to gather all of the evidence that they need to potentially proceed to trial. Here's where we might have some motions as well, and the parties may also meet with the judge for some pretrial conferences. After that comes trial. So that's where we then have the evidence presented. There's a jury. The jury is going to render a decision. There may be some motion work here after the trial verdict, and then ultimately there could be an appeal. We're going to break down further those stages of litigation, starting with the pretrial process. So at the outset of litigation are the pleadings. The pleadings inform each party of the other's claims, they reveal facts, and they specify the issues or the disputed questions in the lawsuit. Again, the pleadings are plaintiff's complaint. So plaintiff starts, right, to initiate the lawsuit, and then defendant answers. Those are called the pleadings taken together. Plaintiff's complaint initiates the lawsuit. It also specifies jurisdiction. So in plaintiff's complaint, plaintiff has to have a statement that says that this court has the jurisdiction to hear this matter, both personal and subject matter. Plaintiff's complaint is going to contain legal theories and remedies. So whatever plaintiff's argument is here, the causes of action, and then the damages that plaintiff is seeking. So for example, a plaintiff and defendant get into a car accident. Plaintiff sues defendant, files a complaint specifying personal injuries suffered by negligence. So in that complaint, we have some sort of remedy, right? Personal injuries, there's going to be a damage amount. Negligence would be our legal theory or the cause of action. And then you have a little bit of fact-based information about details of the car accident. Once plaintiff files the complaint, it is served on defendant, and defendant will respond, sometimes in the form of an answer. There are other ways that defendant can respond, and we're going to talk about that coming up. But typically this answer is going to either admit or deny those things that plaintiff put in plaintiff's complaint. So after plaintiff files complaint and it is served on defendant, now defendant has to respond. We know that defendant can respond by filing an answer. And within this answer, defendant can assert affirmative defenses. Affirmative defenses are when defendant admits the truth of the complaint, so says, yep, everything that plaintiff says is correct in the complaint, but defendant then raises additional facts to show that he should not be held responsible for the damages. For example, we'll take our car accident example from a few slides back. Plaintiff and defendant get into a car accident. Plaintiff sues defendant for negligence. Defendant may answer by raising the affirmative defense of contributory negligence. What that means is defendant says, yep, plaintiff is correct. I was negligent, we did get into a car accident, but there are additional facts here to show that plaintiff was also driving negligently at the time of the accident. So plaintiff was also at fault, and my damages should be limited because of these facts. In addition to an answer, defendant can also respond to a complaint by filing what's called a counterclaim. In a counterclaim, defendant denies the allegations of the complaint. So this is different than an affirmative defense. Here, defendant is saying, nope, what plaintiff says in the complaint is untrue. And then defendant sets forth his own claim that he is actually owed damages. So again, we'll take our car accident. Plaintiff and defendant get into an accident. Plaintiff says defendant was negligent in causing plaintiff's injuries. Defendant says actually the accident occurred due to plaintiff's negligence only, and now defendant is owed damages for his car. So think about a counterclaim as though it's a race to filing the lawsuit. Plaintiff won, but defendant still believes that he has claims against plaintiff. During this pretrial process, the parties may also file motions. A motion is a procedural request submitted to the court by an attorney on behalf of his or her client. These motions can happen pre-trial, during trial, or post-trial. Pretrial motions include the motion to dismiss, motion for summary judgment, and motion for judgment on the pleadings. A motion to dismiss is one of the first motions that may be filed in a case because it can be filed in place of defendant's answer. A motion to dismiss asks the court to dismiss the case for a specified reason, such as lack of personal jurisdiction or failure to state a claim. So, examples: if the allegations in plaintiff's complaint do not constitute negligence on the part of the defendant, back in our car accident hypothetical, defendant may decide to file a motion to dismiss instead of answering the lawsuit. If service was improper, so service of process didn't take place properly, defendant can file a motion to dismiss the cause of action. Or if venue was improper, and venue has to do with the location of the particular case or trial. If a motion to dismiss is granted at the beginning of a case, typically the court will allow plaintiff to file amended complaints and correct any of those errors that may have been in there. Another pretrial motion is a motion for summary judgment. A motion for summary judgment asks the court to enter a judgment in his or her favor without a trial. This typically is made toward the end of pretrial process, but it can be made earlier. This is one of those motions that will dismiss plaintiff's claim altogether. So the court is going to grant the motion if there are no facts in dispute, and the only question is how the law applies to the facts, because that is the judge's job or the court's job. So if nobody disagrees on the facts, then it's not meant to go to a jury. Instead, it should stay with the court, and the judge should make the decision. Typically, this happens right before trial because it's going to be defendant's sort of last-ditch effort to make plaintiff's claim go away. Next in this pretrial process is discovery. Discovery really makes up the bulk of the pretrial process. It's the major amount of time spent and energy spent on behalf of the parties by the attorneys or the law firms working. So discovery is the process of obtaining information from the opposing party or from witnesses, all prior to trial. Essentially, it gives the parties the ability to learn as much as they can about what to expect at trial, and this essentially means that there are no surprises. We're so used to seeing on TV or in the movies that someone runs into the courtroom with this last-minute piece of evidence that's going to change the outcome of the case. That really doesn't happen. Discovery prevents this. Discovery gives the parties the opportunity to ask all of these questions beforehand and talk to everybody so that they know what's going to happen. Discovery includes witnesses, documents, records, and other types of evidence. During this pretrial process, the parties, the court, The entire process is governed by procedural rules. These procedural rules specify what must be done at every stage of the litigation process. These procedural rules are procedural laws that we talked about back in Chapter 1. Examples can be things like service of process, timing of exchange of evidence, any rules that are governing how the parties are supposed to be moving about this pretrial process. Interrogatories are typically the first discovery method to be used in a case. Interrogatories are written questions related to the subject matter of the lawsuit that must be answered under oath. So keep that in mind. Every discovery response is under oath, so you cannot lie. And they can be used in trial as essentially testimony. But here, these written questions are answered in written form. So imagine your attorney is receiving these written questions, and the idea is that your attorney is going to be drafting the responses based on the information that the party provides. You can imagine that these answers are going to be crafted, right, to not give all of the information that is requested, or to give as little as possible while still staying within those legal guidelines. Depositions are sworn testimony recorded by a court reporter and often videotaped of parties and other key witnesses. So depositions typically happen in a conference room of a law firm. The deponent or the witness or party who's going to be giving the sworn testimony will have an attorney present. The other party's attorney will be there to ask the questions. And it is candid, right? You're going to get more candid answers in a deposition because you're sitting across from the person trying to elicit answers. They're not necessarily prepared in advance. They certainly are prepared in that they've gone over the information that might happen, but they cannot write down their answers. So it's like an interview. You're going to be getting more truthful answers, you hope, than you might in some of the other discovery methods. Although it is the most expensive discovery method, it is typically the most effective. Once the parties have gone through the pretrial process of pleadings and motions and discovery, it's time to prepare for the trial process. One way that the parties prepare for the trial process is through jury selection, or voir dire. Here is where attorneys are going to question prospective jurors to determine their bias or connection with any party in the case. These are questions that may go towards stereotypes. So the attorneys may ask the jurors, what are their jobs, right? Because teachers may be more sympathetic, police officers may be less sympathetic. If it is a case that has to do with some sort of criminal act, the attorneys may ask the jurors how they feel about police officers, or if they have any cops or felons in their family. The next step after the jury is selected is for the parties to give opening statements. Here's where the attorneys are going to lay out what should be expected to be heard throughout trial. So both attorneys have an opportunity here to give these opening statements, and they're going to set forth the facts that they expect to prove. It's essentially the roadmap to the jury about what's coming down for the rest of the trial. Once the parties have selected the jury and have given their opening statements, it's now time for the presentation of evidence. Plaintiff will present her case first. It's plaintiff's case. Plaintiff filed the complaint, so it's plaintiff's burden to establish evidence. Part of the presentation here is going to be examination of witnesses. So plaintiff will call his or her witnesses to help prove plaintiff's case. Any examination of plaintiff's witnesses by plaintiff is called direct examination. Once direct examination happens, defendant's attorney will have an opportunity to cross-examine those witnesses. This is more of a heated interaction because defendant's goal is to essentially discredit some of the information that plaintiff's witnesses are putting forth. After plaintiff presents his or her case, it is now time for defendant to present evidence and witnesses for defendant's case. Once the evidence is presented by both plaintiff and defendant, then it is time for closing arguments. Here's where the attorneys summarize the facts and evidence, and this is where they tell their client's story in the most compelling way possible. So here's where you're going to see more impassioned storytelling from plaintiff and defendant's attorney, because at this point they get to tie up the case with a bow. All of the evidence, everything has been shown, the jury has heard everything, and now the attorneys get an opportunity to summarize and really tie together everything that has happened up until that point. After closing arguments, the judge is going to provide jury instructions or charges to the jury on the law that applies to the case, as well as the standard of proof. So if we have our car accident hypothetical, plaintiff and defendant get into a car accident, negligence is going to be one of those jury instructions that the jury is going to have to apply. They will have to then look at that particular jury instruction as they deliberate and argue back and forth with one another about if they feel that negligence has been established. Another big jury instruction is the standard or the burden of proof. In civil cases, that standard is preponderance of the evidence. In criminal cases, that is beyond a reasonable doubt. Essentially, the standard of proof is how much evidence plaintiff has shown in order to prove whether or not that cause of action has been shown. And the jury gets to decide that. Did the plaintiff, or in a criminal matter, did the prosecution establish enough evidence that we're convinced up to the standard? After these jury instructions, the juries are going to deliberate. Here's where they sit down in that jury room and they're going to talk through all of the evidence and see if they feel that the law applies and the case has been proven. After the jury reaches a verdict, either party can make a post-trial motion. This post-trial motion is going to ask the trial court to alter or disregard the jury's verdict or to order a new trial. The two main post-trial motions are a motion for a new trial. That motion asserts that the trial was fundamentally flawed and a new one is required, or a motion for JNOV, or a motion notwithstanding the verdict. This motion asks the court to enter a judgment as a matter of law in defendant's favor despite the jury's verdict. A party may also appeal the jury's verdict or any legal issue, motion, or court ruling during the trial. Once this appeal has been made, the appellate court is going to review the record from the trial court case. Once the appellate court reviews the case, it issues a written opinion that either affirms the trial court's judgment, meaning it agrees, reverses part or all of the judgment and remands, sends it back for additional trial, reverses part or all of the judgment and renders a new ruling or verdict, or the appellate court may modify the lower court's decision. So even after this entire pretrial, trial, and post-trial process, there is no guarantee that a judgment will be enforceable. Essentially, what that means is it's possible for a plaintiff to sue a defendant who is judgment proof. If the defendant has no money to pay whatever the judgment that the court or the jury awarded, some sort of damages, plaintiff's going to have to try to satisfy that judgment in other ways. One way is through a writ of execution. So if the defendant does not have the funds to pay the judgment, plaintiff can request an order directing the sheriff to seize defendant's non-exempt property and sell it to pay for judgment. Things like a car, maybe a house, or some other assets would be sold at an auction so that it can satisfy all or part of plaintiff's judgment, which is just this piece of paper, until it is satisfied with some form of monetary payment.